Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with the update from the Supreme Court. The bench of Justices Sanjeev Khanna and Dipankar Datta today reserved judgment on the batch of petitions seeking 100% verification of electronic voting machine, that is EVM data, with voter verifiable paper audit trail or VVPAT. The petitioners, including NGO Association for Democratic Reforms, pray that all VVPATs be verified instead of the current practice of Election Commission to randomly verify 5 EVMs per assembly segment. The petitioners also seek measures to ensure that voters are recorded as cast and counted as recorded. Today was the second day of hearing. Advocate Prashant Bhushan, appearing for the petitioners, suggested that the light in the VVPAT screen should be kept lit throughout the voting time as opposed to the present practice where the light is kept lit for 7 seconds. This, he said, was important so that the voter could see the slip cutting and falling. Advocate Nizam Pasha, also for petitioners, suggested that the voter be allowed to physically take the VVPAT slip and deposit it in the ballot box. When Justice Khanna asked, wouldn't that infringe the voter's secrecy, Pasha submitted that the voter's privacy could not be used to defeat their own rights. During the hearing, Bhushan also cited a report published by Manorama Online about complaints of EVMs recording extra votes for the Bharatiya Janata Party during mock polls conducted in the Kasaragod constituency in Kerala. Observing that all apprehensions regarding EVMs should be calmed, the bench chose to interact with an official of the Election Commission of India, or the ECI, who was present in the court to understand the technical aspects of security features. The official told the bench that the news report cited was totally fake and that about 17 lakh VVPAT machines are there. He explained that the manufacturer does not know which machine is going to which constituency and which button is allocated to which party. Further, there is no software loading in the VVPAT machine and it is a mere printer. The ECI official also told the bench that there has never been a mismatch between the VVPAT slips and EVM votes ever. Senior Advocate Maninder Singh, appearing for the Election Commission, termed the petitioners' demand for a return to paper ballots a retrograde step. He asserted that EVMs are tamper-proof and beyond manipulation. He said that human error could not be ruled out in manual counting and that human participation had been minimized under the present system. Solicitor General Tushar Mehta stated that such petitions were filed on the eve of elections to cast aspersions on the election system. After hearing both sides, the bench reserved the judgment. Let me tell you, the first phase of Lok Sabha polls commences tomorrow. Stay tuned with us for the verdict on this important matter. A Delhi court today heard Chief Minister Arvind Kejriwal's application seeking permission to consult his regular doctor in jail through virtual conferencing. He said his blood sugar levels were fluctuating and thus he wanted to consult his regular doctor. Kejriwal, as you know, is presently in judicial custody in the alleged Delhi liquor policy scam, and his custody is expiring on 23rd April. At the outset, Kejriwal's counsel, Advocate Vivek Jain, told the court that the application was being withdrawn to file a better application. The Enforcement Directorate told the court that while the Chief Minister was claiming that his sugar levels were high, he was having mangoes, sweets and tea with sugar in the jail. The counsel for ED, Advocate Zohaib Hussain, told Special Judge Kaveri Baweja that Kejriwal wanted to create an increase in the sugar levels as a ground for bail in the money laundering case. The submission was opposed by Jain, who said that Hussain was playing by the gallery and was making submissions for the media. While the court disposed of the application, it listed the matter for tomorrow and has asked the Tihar jail authorities to file a medical report on Kejriwal, including his diet. The Delhi High Court has quashed the circular issued on 12th March by the Union Ministry of Fisheries, Animal Husbandry and Dairying prohibiting the import, breeding and selling of several dangerous and ferocious dog breeds. A division bench comprising of Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora quashed it after the Union Government's Council said that there was no objection if the same was set aside, with a direction to issue a fresh circular after giving an opportunity to all the stakeholders to raise their objections. The court directed that the central government shall issue a public notice in the national newspaper as well as on ministry's official website inviting written objections to the proposed or draft notification to the rules within 2 weeks. With this, the batch of pleas challenging the notification on the ground that the ban was imposed without consulting or inviting objections from the stakeholders was today disposed of. The Madras High Court has observed that merely smelling alcohol in the breath of a person brought to the hospital by itself is not a ground to attribute contributory negligence to the person in motor accident cases. The court noted that in most cases, the doctors merely indicate the breath smelled of alcohol without making any effort to find out the percentage of alcohol in the blood. The court was hearing an appeal where the appellant challenged the order of the Motor Accidents Claims Tribunal and was seeking an enhancement of compensation. The tribunal had attributed 50% contributory negligence against him on the ground that he had not maintained safe distance from the lorry involved in the accident and that he also smelt of alcohol when he was being treated by the doctor after the accident. I would like to tell you here, Section 185 of the Motor Vehicles Act pertains to driving under the influence of alcohol or drugs. It states that if a person is found to have alcohol concentration exceeding 30 milligrams per 100 milliliters of blood detected through a breathalyzer test, he is presumed to be under the influence of alcohol while driving. It is automatically assumed that the person was not in proper control of the vehicle. In the present case, since no assessment was made regarding the percentage of alcohol in blood, the court observed that the same was not sufficient to attribute contributory negligence. Justice Anand Venkatesh added that this determination was important to ascertain whether the person who consumed alcohol was within his control to drive the vehicle. The court thus directed the Ministry of Health and Family Welfare to issue circulars to all hospitals, including private hospitals, to assess the level of alcohol in blood when an injured or deceased is brought and smelt of alcohol. The court allowed the appeal and modified the order of the tribunal. In a significant update, the Karnataka High Court has held that duty of an institute to provide better working conditions for specially abled persons is not just a moral imperative but a legal obligation. In this case, a professor with 85% orthopedic disability applied for a faculty position at Indian Statistical Institute in 2006 and was appointed as assistant professor in 2008. Despite expressing a preference for the Kolkata campus, he was directed to join the Bangalore Center. Though he had informed the head of the Bangalore Center about his physical condition and accommodation needs, but upon arrival, he was accommodated in a single-room guest house, which was meant to be temporary but has persisted since 2009. The guest house lacks essential amenities for someone with disabilities. The petitioner had to cook his own food in the absence of dining facilities. He even had to prepare meals in the toilet area due to the lack of a kitchen and the heating point being available only there. This indeed poses health and safety risks. The court noted that the petitioner is an expert in human EEG and ECOG signal processing and relies on an electric chair for mobility. Despite being appointed in 2009, suitable accommodation had been denied by the institute without clear reasons. A single judge bench of Justice Sachin Shankar Magdam allowed the petition filed by the professor. The court quashed the direction issued by the institute to withhold payment of HRA paid to him on the ground that he was staying in the guest house provided by the institute. Further, the court also directed the institute to expedite the process of building new quarters for the petitioner, ensuring that it meets all accessibility and accommodation requirements specified under the Rights of Persons with Disabilities Act of 2016. And now an update regarding the case of a man missing from Isha Foundation founded by Sadhguru. The state government today informed the Madras High Court that investigation in the matter was underway. The bench of Justice M.S. Ramesh and Justice Sundar Mohan was hearing a habeas corpus plea filed by one Tirumalai to produce the body of his brother Ganeshan. In the previous hearing, the additional public prosecutor had orally informed the court that since 2016, 6 people had gone missing from the foundation. Today, when asked about the details of the investigation with respect to the earlier submission, the prosecutor informed the court that the investigation was underway and 5 out of the 6 missing persons had been traced. The court was further informed that the remaining person to be traced was the petitioner's brother, and 36 witnesses had already been examined, including officials from the foundation. The state requested for further time to complete the investigation and for filing the final report. Accordingly, the court adjourned the case to 7th June. And lastly, a Delhi court today postponed the order on framing of charges against BJP MP and former Wrestling Federation of India President Brij Bhushan Singh in the sexual harassment case filed by the women wrestlers. The alleged incidents of sexual harassment are said to have occurred between 2016 and 2019 at the WFI office, at his official residence, and also abroad. Singh has sought a direction on the Delhi police to investigate regarding his presence at the WFI office on 7 September 2022. This is the alleged date of the incident. He has claimed that on this date he was not in India. The Delhi police opposed the application and said that it had been filed at a belated stage. The complainants also objected, saying that the application was a delaying tactic. Additional Chief Metropolitan Magistrate Priyanka Rajput of Rouse Avenue Courts deferred the order on Singh's application. Singh is presently out on bail along with co-accused Vinod Tomar, who is the former Assistant Secretary of the Wrestling Federation of India. Thank you for watching. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.